about, of course, is the Supreme Court decision
Right.
on the antitrust with the NCAA yesterday. I'm not surprised at all. What happened yesterday is the Supreme Court affirmed a decision from a trial court from a couple years ago. The trial was actually a suit brought asking the players be paid. The trial judge said no, they don't get paid, but they get everything they need for their. The NCAA cannot deny a college the right to provide everything necessary for education. That would include like laptops, cameras for some classes, musical instruments for some classes, whatever. So there were limits that the NCAA had in place that prohibited schools from providing absolutely everything. The trial court said you can't limit those things. Supreme Court yesterday upheld that decision.
So is that how far it goes? I mean, what is the latitude now that a player can use legally to ingratiate themselves financially?
Well, see, this is separate from name, image, and likeness, which kicks in our state, next week, July 1st, which allows really for more making money. What this really was about was the NCAA had limits on that told schools you can't give more than this amount, and the NCAA's theory is we're trying to balance, so we're not going to let some schools give everybody a free laptop, and other schools can't afford to do that. So there's some schools that really didn't want to see the case come down the way it did, because there's some schools that can't afford to give everybody a laptop.
All right. So in other words, what you're saying,
the schools
Ron, is
don't
that
have to give everybody a laptop or give everybody a musical instrument or whatever. They don't have to do that. What that case did yesterday was it said the NCAA can't have a rule that precludes schools from doing that. So that's what really got struck down. It limited the NCAA's authority. So now there's going to be competitive. There's going to be competition that's going to drive coaches. Coaches are going to be able to tell, hey, you come here, we're going to give you everything. You're going to get a laptop, you're going to get this, you're going to get that. So competitive forces, certainly in schools like the SEC level, are going to drive more benefits to the students. But what yesterday really was about was, educational benefits. The name, image, and likeness stuff coming down the pike in a week or two, that's where there's going to be more outside income.
So does it open more misuse of this or some creative out of? Can you hear me? All right, hang on here. Let's see if we've lost it, because I think he's lost it. Ron, can you hear me? Can you see me? Can you hear me or can you see me? Prez, do me a favor. Would you cut him there and then get on the phone?
I can hear you now.
Phone? Oh no, okay, we got it.
Just came back.
Momentary lapse. Are we back? You got a lot.
I can hear you. I don't know where I cut off. I'm sorry, but I was really brilliant though.
Right. Yeah, no. You were brilliant, and we got it. We got the lapse, and we caught everything you said though. Let me see if I can regroup. So it really doesn't, because I thought when I first heard this, it was more bombastic than that. It gave them the right to go out and actually be almost like at the pro level. But you're saying this really was not that big of a deal. It just has to do with educational material, that which is defined by the education itself.
That's what the case yesterday really was about. I was, as you might suspect, reading up everything I could, and somebody I thought made a really good point. The NCAA always says only 2% of athletes go on to play professional past college. This decision yesterday related to the 98 who don't, to make sure that the NCAA cannot prohibit schools from giving them everything they need.
Does this have anything? You said the next thing coming down is this week or next week. What was that?
Well, the name, image, and likeness rules. Now, we have a law coming in the state of Mississippi, and it's coming in 5 other states, Florida and California, where student athletes – Right, July 1st. Student athletes are going to be able to profit off of their name, image, and likeness. And that's where especially star players – are going to be able to negotiate contracts with anything from, a major shoe company to a local TV repair shop. I don't know, they don't even have those anymore, but but you'd be able to make public appearances and do things for pay.
So how's that going to work, though? I mean, because if you get, let's just say you have, God forbid, a major car dealer, I mean one of the biggest in the country, comes in and says, look, if you go to school A, we're going to have an endorsement. Could they do that and consummate the deal before the guy signs?
Well, I mean, here's the thing. The rules vary from state to state, the 6 different states. Yeah. The NCAA and college sports in general, I think, are trying to work with Congress to develop national standards, and there's hope for a national law that will hammer out things like that. But that's absolutely the concern, is that every football player in Alabama is going to have a deal with a car dealership somewhere in the state. And it's going to drive much more competition into trying to, and which will lead to a competitive imbalance. Those are the concerns.
So since it's going to be state to state, it would be that's going to matter as far as within the SEC itself. So it'll be different from Alabama to Ole Miss.
Right, and technically, the point is the law that's coming into place in Mississippi says we can't prohibit student athletes from benefiting off of their name, image, and likeness, while at the same time the NCAA does prohibit that. And so technically, to abide by the state law, we're going to be in violation of NCAA regulations. So the NCAA has to somehow adjust its rules to accommodate those schools who, by law, can no longer follow the NCAA rule. And that's, I think there have been very clear indications the NCAA is going to waive that rule in the states where it's a matter of law, but only in those states where it's a matter of law. So other states are not going to necessarily have their students be able to benefit from name, image, and likeness. And that creates an imbalance in terms of trying to recruit the top high school athletes for next year.
It is amazing. It's almost a little bit like marijuana, recreational versus medical, and the federal versus the state. It's the people who are there to uphold the law, make the rules and regulations, and abide by them are more confused now than ever before. And it sounds like you guys going forward with the decision of the Supreme Court yesterday and with this one coming up state by state, it's going to be a maze of the lawyers are going to be needed more now than ever before.
It's incredibly complex and confusing, and trying to abide by laws and NCAA regulations and do right by the student athletes and the university. I know people in administration here at the university and across the SEC. It's very complex. They're working very hard to try to do the right thing, and it's hard when you got these kind of mixed signals.
Yeah. Do you think it's going to change sports at the college level?
I think ultimately it has to. At some level, it has to. Now, it may be better, and it may, things may work out just fine. But it's a frightening time in a way if you're someone who's worked around athletes and you're suddenly seeing all these rules change at once. You're trying to figure out it's not going to look exactly the same, and hopefully it'll be still something that's good for the student athletes, good for the institutions, and good for the fans.
Is there need to be a retooling of the way that the kids are signed, or I'm just looking at this as a taxpayer. If a guy comes in and he's getting, let's say, a couple of $100,000 to play for 4 years there, and we as the taxpayers are really kind of footing the bill for a scholarship, do we need to do that? I mean, it could be a lawsuit from a class action from citizens saying, no, if you're gonna get that kind of endorsement above and beyond what the scholarship is, then no, we're not going to pay for the scholarship.
Well, I don't know if I see that coming, but I do see issues with tax complications. Student athletes suddenly finding that being a serious issue.
Could you hold on for a moment? I also want to ask you about this other thing dealing with religion, but a couple of more questions from for Ron Rychlak. All righty, let me get back with Ron Rychlak, Associate Dean for Academic Affairs. And again, available at supertalk.fm/watch and also C Spire Text or C Spire TV on Channel 70. And we kind of have more clarity on this one. Thank you to you, sir. The Supreme Court ruled in a unanimous decision yesterday that the NCAA has illegally restricted education-based benefits that could be used as compensation to students athletes, which in my feeble mind here, thinking that means like some universities were restricting or making them pay for classroom supplies. And there were a group of current and former students, as well as men's and women's basketball players, who filed a lawsuit, and the Supreme Court voted 9-0, saying, no, you can't do that. You have to provide it. Is that basically it?
Universities still could decline to do it. It's the NCAA couldn't have a rule that restricted universities from doing it.
So what was the game?
It's
by
the NCAA's
players?
authority. The NCAA lost authority there.
Are we talking about a lot of money in this, though? I mean, I don't understand exactly when we.
Cumulatively, a laptop for every athlete, a band instrument for any athlete who's in a band class, or a digital camera if you're in a photography class, those kind of things. The original lawsuit actually, remember, was seeking to have these athletes paid. At the trial level, the trial judge kicked that out and said it's only academic-related expenses. And the Supreme Court yesterday upheld what the trial court did.
Yeah, and Gorsuch basically said that he made it clear that the athletic organization can still enforce the rules that forbid schools from paying students salaries or giving them outlandish gifts to lure them into the program. I think they call that the No Lamborghini Rule. Under the current decree, the NCAA is free to forbid in-kind benefits unrelated to a student's actual education. And again, it just seemed like it was more of a bombastic ruling yesterday than this. Let me go behind the scenes a little bit and ask you, though, because there were a couple of times when Gorsuch basically said, to the extent the NCAA means to propose a sort of judicially ordained immunity from the terms of the Sherman Act for its restraints of trade, that we should overlook the restrictions because they happen to fall at the intersection of higher education, sports, and money. I would take that to mean you can't break the law just because it's in the sanctity of the education environment. But
that's right. That was in the majority opinion. And if you look at Kavanaugh's concurring opinion, he was even more bold about that. Kavanaugh, I think, would have gone further. He's a little more. I read somewhere someone wants to drink beer and be a sports fan and yell at the NCAA. He was ready to burn it down a little bit more.
Could you read into this though? And I wonder how the tech companies would look at this, because they were talking about basically a monopoly in some forms. But you think that this has any little hint to the Facebooks and Googles and people such as that? Would you think that they could look at this and say, geez, that makes me feel a little uncomfortable?
Well, yeah, I mean, that's actually a very good point. The Supreme Court, by a series of 9-0 decisions recently, including this one, it has maybe been messaging a little bit that they're unified in some things, and one of those things could be the way the court views antitrust, and some of the big social media companies certainly are bordering on, if not monopoly, at least exceeding the limits of the Sherman Act.
It just makes you wonder, did they call a special meeting and have some lawyers saying, okay, let's get into this? The other thing, too, and I heard somebody talking about
they probably don't need lawyers.
That's true. Ron Rychlak is my guest. The other thing I heard somebody say yesterday, and I thought this is a very valiant point, these 9-0 decisions. Anybody hears the Supreme Court, whether it's the state or the U.S. Supreme Court, are always good to hear a 9-0. But we get a lot of 5-4s, 5-4, 5-4s, and when you do that, it sounds political. And somebody mentioned yesterday, and I forgot where the article was I read, is this a way for the Supreme Court to say, look, guys, you people in Congress and the House, get away from packing the court. We don't need that. We can show you that we can be unanimous, and we're not all political at 5-4. Do you think anybody can read stuff into that?
Well, yeah, I've seen quite a few people suggest that the court with the 9-0 decisions is perhaps saying, look, don't think by throwing 3 new justices on here you're going to turn, flip things around. We are much more in agreement than it may have seemed sometimes in the past. So, I can't rule that out. It's nice in a way to see 9-0 decisions, because it means 9 really smart people agreed that this is how something should be understood, instead of having the 5-4 kind of stuff and the political kind of situation. But and if it stops the court packing discussions, that would be great, I think.
Yeah, I doubt very seriously it'll stop that, but it's much like the HB1 and SB1 going. They're trying to get it passed as far as redoing the election process in this country. And I'm amazed that they're that bold to do this, because, number one, and we heard from Lindsey Graham a few moments ago, talking about changing even the way that things are redistricted, having the feds control the redistricting, which is, I believe it's in our Constitution, that this is left up to the states, not to Congress. But if this thing did actually pass, it would be nation-changing as far as the Constitution. Would you agree to that?
I absolutely agree. And as I understand the Constitution, I don't see how you can actually do that.
Yeah.
But again, some bold political moves. Sometimes people try them.
Just good to have you on, because we were talking. You're the master of disinformation in the books that you've written, and boy, you talking about that. You look at Fox News was reporting a few minutes ago that the latest polling on the favorability of voter ID in this country is 80% of Americans, and that's a cross section, white, black, and brown. 80% like voter ID, not voter registration, but voter ID. But you don't hear that from the media. You would think just the opposite, would you not?
No, yeah, you're absolutely right. There's an agenda that an entity wants to advance, a news entity, whatever wants to advance. You're not going to hear counter evidence, and that's very frustrating.
One final question here, because, and I know with your connection to the Vatican and the work that you do there, did you hear Congressman Ted Lou threatening the Catholic Church? I dare you not to give me communion. I just think that was one of the most bombastic statements that I've heard in a long time from the brashness of a congressman.
Yeah, no, you're absolutely right. And obviously, some bishops, some priests, when someone is very, particularly a public official, a congressman, is very much standing in opposition to their own church, that church has some remedies or whatever, whether it's denying communion. It seems to me that's up to the church to decide. And we had a Supreme Court case just this week also that upheld the Catholic Charities' ability to abide by its own dictates and its own faith. So, the boldness of politicians, including a number of politicians that came together this week, Democratic politicians came together with sort of a demand that the Catholic Church change its teachings on a number of family and social type things.
Yeah, I've said this a long time ago. I don't know how that leftist movement, whether it's the LGBTQ and the demands, and I'm talking about the radical part of that, or the radical part of the pro-choice people, how they can survive in the future going with religion itself. It's one of those things that they're not going to come together, and one does not want the other one to coexist. But how do you do that?
If I knew that, we could rule the world, Paul. I mean, I don't know how you bring very diverse ideas together, especially when there's a lack of tolerance. And we have accusations of lack of tolerance against the church. I think there's a lot of times the church finds little tolerance from society.
You working on a new book, or are you?
I'm always working on something. I'm working actually. There's some serious negotiation with a movie deal for disinformation. Actually.
Oh, really?
That's very exciting.
More about that? Yeah.
Yeah. No. My publisher contracted with a movie outfit in Hollywood Then and River Rock Entertainment, and they have a web page now that shows the in production. I just kind of found out about it. So.
Yeah, I want to talk more about that as time goes on and it takes a little bit more of material status. Let me know. But make sure, whatever you do, have Matthew McConaughey play you, one way or the other.
Of course.